Yes.
Okay, so this is just a document summarizing kind of how we got here. So as I mentioned, we have obtained a default judgment against Mr. Brown individually in 2018. Subsequent to that, in April of 2020, we obtained an agreed judgment against Mr. Brown and his trust for all of the amounts of the previous judgment, plus some additional attorney's fees and other amounts. So the agreed judgment basically says everything that Mr. Brown was on the hook for in that 2018 judgment, the trust is also jointly and severally on the hook for. So that's these are the judgments that provide the backdrop for the case. Now, as I said, there's a lot of water, as Your Honor knows, there's a lot of water under the bridge here, but just focusing on the most recent order. This is the order that this court granted in September of this year, requiring Mr. Brown to provide an affidavit listing the identities of the individuals and entities funding him as described in the discovery order. So he was required down here at the bottom within 14 days of this order to provide this affidavit with describing other things in reasonable particularity, the nature and means of such support. In other words, Mr. Brown had previously provided bank statements and said, hey, it's all in the bank statement. Just look at the bank statement. Well, the bank statements don't tell you a lot. They just show deposits coming in through his management company, but without providing the background of what the original source of those funds is. So the idea behind the relief we were seeking here was to force him to finally just identify who is funding him, who is paying the bills, what are his sources of income specifically. And this is what he was required to do within 14 days of the order. He was also required under this order to produce monthly credit card statements for each and every account, whether in his name or not, used to pay his living expenses, including 2 credit card accounts that were specifically identified in this order. So that's the order, that most recent order, right? So within 14 days of that order, Mr. Brown produced nothing. There's no affidavit or declaration. There's no effort to identify individuals and entities, the nature and means of support, and no credit card statements. So that deadline came and went with no action from Mr. Brown. Instead, just 2 days ago, we received, as is his custom, a handful of documents that are presumably intended to kick this down the road again. So these included a handful of bank statements from this year for the last 6 months or so from a single bank account. And they included some screenshots from a Cash App that apparently shows Mr. Brown sending cash to his children and dependents to support them. That latter piece was not responsive at all to the most recent motion to compel. So in short, even after this document production 2 days ago, has still failed to identify with reasonable particularity the identities of individuals and entities providing support, the nature and means of support, or any credit card statements. Instead, all he's offered in this bare bones affidavit is this statement, this conclusory statement. I have made multiple attempts to obtain records for credit card accounts ending in these 2 numbers, but I have not been able to obtain any access to those records. I have no access to those records. So there's no detail of his efforts, times, dates, what he did to try to comply with that part of the order. And as we'll see, the bank statement suggests there are additional credit card statements that he's paying for which no statements were produced. So what did we get from Mr. Brown? Well, we got a bunch of bank statements from a single bank account starting from May of this year to the present. And what they have is, and this is what Mr. Brown points to as apparently to satisfy his obligation, they have a number of generic descriptions of the type of deposit coming in. There's no effort in the affidavit to identify for any of these, and definitely not for each of these, where's the money come from, what's the entity or individual behind it. There's huge cash deposits coming in over the last 6 months with very little explanation. For example, fire insurance, this appears to be insurance related. We don't know, we're just guessing. There's been no explanation. There are a number of deposits from this Fritz Martin Management LLC. A number of them are very large. We understand that to be Mr. Brown's management company. In other words, all the payments that are flowing through to him the trust, however he wants to try to characterize it, flow through that. A lot of them flow through that management company. Well, that doesn't tell us anything about the original source of those payments, which is what he was required to do under Your Honor's order. As you see, there are additional payments in June and July, and then a handful of these, Your Honor, that just say deposits of thousands and thousands of dollars with no explanation of who's behind it and what it is. And as you can see, the dollar amounts here are significant. So this is what bank statements show, a number of these payments coming in. This one appears to be for the NFL, but there's no explanation of whether that's a kind of a paid gig, or is this from a type of a retirement account that might not be subject to collection. We have no way of knowing that. $5,000 deposit, another $5,000 deposit could be cash. We don't know. So you get the idea. We have just the most meager explanation of the sources of these funds to Mr. Brown. Meanwhile, we also have significant payments to what appear to be credit cards, or at least other accounts, for which statements have not been produced. So you have numerous statements to this account ending in 0136, and another payment to this account ending in 9231, right? And so under the court's order, if these are credit card statements, and these are two new accounts were not identified in the order, in the September order. All these credit card statements should have been produced under the order within 14 days. These statements also show thousands of dollars on non-essential items. It's clear that Mr. Brown is well above subsistence level living, more than $1,000 in massages, pet grooming, lots and lots of DoorDash orders, housekeeping, pool maintenance, golf outing, and apparently is still getting free rent in a really nice house in Cedar Hill where his neighbor is Deion Sanders. So what we're asking for, Your Honor, is simple, that Mr. Brown be confined until he complies with the court's order by providing sworn affidavit of the individuals or entities providing his support, and by producing, I should say, all credit card statements for those accounts identified in the bank statements and the accounts identified in the previous order, or a detailed explanation of all the different steps he's taken to try to obtain those accounts. Your Honor, it's clear that Mr. Brown is just not taking this court's order seriously. He is playing games, he's ignored, and he's hoping to kick this down the road again. And at some point, it has to stop. And I think we have been down this road many, many times. Your Honor has specifically warned him more than a year ago. You've got to take this seriously, or I will have to put you in jail. He's obviously not taking it seriously. And so this court should exercise its inherent power to enforce its own orders by confining him until he complies.
Your Honor, I'm not sure exactly what the end game here is from the plaintiffs, other than trying to show us.
Mr. Walker, I think it's clear what the end game is he wants to collect the judgment.
Well, I understand.
Your client
that.
has not complied with court orders.
No,
and
Your
so,
Honor, Your Honor,
Mr. Walker, you're jumping into this late in the game, and I'm not fussing with you, but this has been going on way too long. We've had way too many hearings where your client just hasn't complied. And the question in my mind, I don't want to put him in jail, but I don't really see any of their options. He's clearly not complying with the court orders. He's clearly hiding assets. And, you know, I agree with Mr. Nelson that he's obviously just treating this as some kind of game that he can, and, you know, there's a judgment here that he needs to pay, and he's not paying it. And so and he's not complying information that he was ordered to required to provide. And so my thought on this is that we attach him, bring him into the courthouse, do a deposition, give him one last chance to comply, bring all the documents that he's supposed to comply with. If he doesn't comply, then we put him in jail until he does comply. Now, I don't know about this affidavit thing. You want affidavits from people who are giving him money? I'm not sure that can be required. Is that what you're saying?
No, Your Honor, we're talking about an affidavit from him detailing who's giving him money.
Okay, I think that would probably be I would suggest doing the deposition, have him bring all the documents he hasn't
Right.
brought, and then if he doesn't comply with that, then we put him in jail. I mean, there's this has been going on for so long. We've had so many hearings. You know, I was like many others here in Dallas were a fan of Mr. Brown, and he's was a great football player, but everybody has to comply with the law, and he's just not done that. And so, Mr. Walker, I'd urge you to be careful about what you say, because really what I should do is just put him in jail. But if you want to keep arguing, you can.
Well, the one thing I want to point out, Your Honor, is that he doesn't have any credit card accounts. All the accounts that he has have debit cards. And what we're trying to do here is provide all the information that we have.
You provided information well after the 2-week deadline. You provided it right before this hearing. The court had to have yet another hearing on this.
And
I mean,
with that,
you need to comply. And I don't know if it's your fault or his fault, but this has been going on too long. We've had too many hearings on this.
sure. And
Do you
with the
prefer
order, with
if
the
I
timing,
just
I'd like
put
to
him
address
directly
that
into
real quick.
jail, or do you want to have a chance to have him do a deposition first?
Well, absolutely, the deposition, Your Honor. And the point about the 14 days, we were not aware that the court had signed any order. We had never received any order until after that deadline.
Mr. Walker, it's your responsibility to check with the clerk's office to see if orders are signed. The court doesn't send out, or the clerk doesn't send out orders. You need to contact the clerk's office on why that is. They don't send out orders. It's your responsibility to check that. And if you didn't check it, that's your responsibility. But I signed the order, and you're supposed to check to make sure it gets signed.
Yeah, Your Honor, on this point, just very briefly, at the last hearing, Your Honor had given instructions to try to reach agreement on a form of order granting the motion to compel. We attempted to do that. We did not get a response, so we submitted.
Oh, yes, you did.
Okay. Ultimately, we're not able to reach agreement, but we submitted a form of proposed order to the court with copy to Mr. Walker, asking this court to sign it. And so the notion that there was not proper notice of the possibility this court would be signing an order it's just not credible.
So the question just is, when do we want to do the deposition, I guess?
Your Honor, from our perspective, as soon as possible, just subject to Your Honor's availability.
I don't want, if it is a situation where we may have to put, and I really don't want to put him in jail, but if it is a situation we have to put him in jail, then I'd rather do it after the holidays so he can spend the holidays with his family. I'm thinking maybe January 14th.
I'm not sure if I can do that, Your Honor. I've got a federal trial that starts on the 10th, and I don't know how long it's going to last or whether we're going to get called on the 10th or on the 12th or when. The week after that, I should be fine.
You guys want to do the 21st?
Sure, Your Honor, we'll make that work.
Okay. 21st at 9 o'clock.
Sure.
So the way this will
clear my schedule.
What did you say?
I will clear my schedule.
So what we'll do is, Rhonda, you need to reserve us a conference room. Actually, we probably can use our jury room, but we'll try to get a conference room for you. You'll report to the court at 9. We'll assign you to wherever you're going to do the deposition. Make sure the court reporter gets there a little bit early. And then I'll be there if you need any rulings. I won't be sitting through the deposition, but I'll be there at the courthouse. And I would just urge, and if you could let Mr. Brown know that there is the possibility that he's going to be incarcerated, so he should probably put his affairs in order. We'll have a arrest team there present as well. But Mr. Nelson, you need to get a attachment and confinement orders ready for me so that I can, if he doesn't comply, we can put him in. I want to give him one last chance, but this has been going on way too long.
And Your Honor, on that point, what I would like to be able to do is ensure that he is able to do everything he can to get the types of details of information that are expected of him. So I don't know to what extent, to what minutia the details are on whether it's the different transactions or whatever. But if we're going back multiple years and there's a deposit that's cash, I don't know if I think that's almost an impossible ask to say.
Mr. Nelson, what I want you to do, I thought you did a pretty good job with that PowerPoint, but I want you to provide exactly the information you want from him. You should have a pretty good idea at this point on that, and provide that at least 7 days before the deposition. Prepare an order on this, Mr. Nelson, and let's hope we can avoid putting, I don't like putting anyone in jail on these.
Absolutely.
Cases, but at this point, just having hearing after hearing where the orders keep getting denied or getting ignored doesn't do us a whole lot of good. And so we need to Mr. Brown needs to understand that there's consequences and for not obeying court orders. And so get me an order on all that, Mr. Nelson, share it with Mr. Walker. Make sure that the order says at the beginning that this was heard on December 17th, 2021. Have that at the beginning of the order. You might want to, just because of the severity of this, when you see the order online, make sure you share it with Mr. Walker as soon as you see it, and email me a copy of the proposed order as well as e-filing it, or email my court coordinator. All right. Anything else, guys?
All right, thank you.
Thank you. All right. Bye, guys.
Thanks. Have a good weekend.
Okay. Our next hearing is Lyons v. Moy Construction et al.
Your Honor, this is Amanda Brown for Biot versus Michael Antonelli. I had emailed your report earlier this week. I have another hearing at 9:45 today.
Oh, okay. Yeah, you're right. You did. Let me take care of that one next. I apologize. I just didn't remember that. Let's go on the record, Tony, on DC 2116103. Counsel, make your appearances.
Amanda Brown for plaintiff Biot Medical.
Michael Pazzulli for Michael Antonetti, and DNA Health LLC, the defendants, Your Honor.
All right, let's proceed.
All right, Your Honor, as you may recall, last Friday we had a hearing set for plaintiff's motion for expedited discovery. And Your Honor requested that we reset it for this Friday after defendants had filed a motion to dismiss under the TCPA. And you wanted briefing on the issue of what discovery would be permitted now that that motion had been filed, and both parties have now submitted their briefing on that. Biot is requesting discovery related to defendants' motion to dismiss under the TCPA. Specifically, we're requesting discovery that's related to the ability of plaintiff to establish the prima facie case of the business disparagement claim that is at issue here, as well as discovery related to the potential exemptions that would apply under the TCPA, being the commercial speech exemption, as well as the exemption for disputes between employer and employees related to trade secrets or non-disparagement and non-compete agreements. And we'd also be seeking discovery related to whether or not defendants have brought this motion to dismiss solely for purposes of delay. All of those areas courts have found are appropriate for discovery when there's a pending motion to dismiss under the TCPA. We actually had prepared discovery and served it on defendants prior to their filing of the motion to dismiss. And given the nature of this case, which, as you may recall, Your Honor, Mr. Antonelli is a former employee who has a confidentiality agreement, including restrictive covenants, such as a non-solicit, a non-disparagement, and a non-disclosure. And we brought a petition for seeking injunctive relief and for claims under the Trade Secrets Act, misappropriation of confidential information, breach of contract and business disparagement. And we were moving towards a temporary injunction hearing when this motion to dismiss was filed. So we've already prepared discovery and served it on defendants. They've had that for a couple weeks now. It's very narrowly tailored because it was prepared for an expedited basis for the TI hearing. And all of that discovery we feel is still proper now that the motion to dismiss has been filed. They've moved on the business disparagement claim, which is, given the factual allegations here, ties into the breach of contract claim because that also includes a non-disparagement provision. And then also the exemptions that we would be exploring, right, for either the commercial speech exemption or whether this is an exempt case because it stems from an employee-employer dispute on trade secrets or a non-disparagement. All of those exemptions, all that discovery would be proper under the discovery that we've already prepared. So we would ask the court to allow us to move forward with that discovery.
Mr. Bazzuli?
Thank you, Your Honor. Let me start with the proposition that once the motion to dismiss is filed under the TCPA, the defendants have now conceded that an automatic stay under 27.003.
Mr. Bazzuli, I'm very familiar with the law on this, so
Right, okay.
I get that.
All right, here's the point, that all they have, what we've moved to dismiss on is business disparagement. They haven't even established a prima facie case of business disparagement. What they've done is they've said on information and belief, Antonelli has made remarks regarding Biot's
Mr. Bazzuli, just to kind of short circuit this, I'm going to allow discovery. It's the extent of the discovery that I'm really concerned about. I almost always allow discovery in these types of situations.
And I understand.
If there's something that she's requested, and I think, for example, the thing about is this for unreasonable delay? I don't know how that would kind of be so broad. It would swallow up any discovery, and I'm not sure how you even do that. I think that's just more of a, but generally, is there any of the discovery she's requested that you have an issue with?
Absolutely, Your Honor. I mean, because essentially she is asking for everything in the case. The law, as you know, is it has to be strictly limited to business disparagement claim.
Why don't you share screen the discovery she's requested and tell me what you
In fact, I have it right here waiting.
Perfect.
And Your Honor, I would say we submitted a case with our letter brief, hydrochemical out of the Houston Court of Appeals, where the court had, in support of its award of fees because the motion had been brought solely for delay, the court pointed to discovery on the issue of whether it was brought solely for delay, pointing to the fact that the plaintiffs knew or the defendants knew that they were covered by restrictive covenants when they filed the motion to dismiss, and then proceeded with the motion to dismiss anyway. So it's not that we're seeking extensive discovery about it, but we want, to explore whether Mr. Antonelli was aware of the confidentiality agreement when he founded his competing venture, because that's something that he is denied.
Okay.
No, Your Honor, they have a non-solicitation. They do not have a non-competition agreement. And what we have, if you look, first request is any and all signed agreements between Antonelli and Biot regarding his employment. That has nothing to do with business disparagement.
Well, Your Honor, we would argue that relates to the exemption as to whether this is a dispute that stems from an employer and employee agreement containing a non-disparagement or a non-compete. And you can call it a non-solicit. If you read it, it's essentially a non-compete.
So request for production number one is going to be, I don't know how to, any objection to that one will be allowed. Request two.
Preparations to form DNA Health. That has nothing to do with their claim, Your Honor, is that he made statements to prospective practitioners that the products were overpriced and they will not receive benefits commensurate with the price. This has nothing to do with that. It has to be strictly limited to the claims under
I will say this one does seem too broad to me.
Your Honor, in that hydrochemical case, another point of discovery that the court relied on in its rule that the motion had been filed solely for purposes of delay was the fact that the employees had taken actions while they were still employed to compete. And that's what Mr. Antonelli has done here in our belief. We found documents that were created for this DNA Health entity while he was still employed with Biot. So we're trying to find out the full extent of his preparations to compete.
But it
on
says
the
all
field.
documents relating to DNA health. I mean, that could be, I mean, that's just way, I mean, I wouldn't even allow that in regular discovery, much less the limited discovery you have here. That needs to be tailored somehow.
And we would be fine with tailoring that to documents evidencing his preparations to form DNA health.
Okay. All right, that seems more reasonable response.
I still, I think that exceeds the issue of whether under specifically business disparagement, whether the products were overpriced. They're seeking to just expand by this argument to get anything they want from him. And I just don't think that's reasonable under.
I'm going to allow all documents relating to, so you take out to DNA, or all documents relating to preparation to form DNA health and those evidence communication. Yeah, so it's going to be all documents relating to DNA health, all documents relating to the Antonelli's preparations to form DNA health, and then the rest of it can stay in. So you can change it to say that. All right, next one.
3 is documents relating to or evidencing Antonelli's job title, compensation package, and job description and duty of DNA health. Respectfully, it has nothing to do with the defamation claim or a business disparagement claim. Again, he does not have a non-competition agreement.
Yeah, I'm not sure why this would be relevant at this point.
Your Honor, we'd be fine with withdrawing that one.
Okay. 4.
All forms, documents, procedures, plans, or strategy documents created by Antonelli on behalf of
that were derived from or duplicated from Biot. Yeah, that's fine. 4 is okay. So that one's going to be allowed. 5. I don't understand 5 at all. So
if I can explain, Your Honor, not only have they served discovery on Mr. Antonelli, they've served discovery on 3 completely independent non-parties, LIV Health, TMC, and TaylorMade Health. And they filed that with the court demanding all these documents from non-parties also in their discovery request. And now they're asking that we provide information on non-parties.
And Your Honor, I can address number 5 and that argument quickly, with mindful of the time. So this is a business disparagement claim that they've challenged, and we're trying to explore any sort of communications that Mr. Antonelli or DNA Health have made related to nutraceutical products. In support of his pleadings, Mr. Antonelli submitted an affidavit that admitted that he's been working with Biot's vendor, TaylorMade, and has actually purchased this BPC 157, which is one of the nutraceutical products at issue. So we have before they file their TCPA motion, prepared subpoenas to TaylorMade to explore those communications, and we certainly would want to continue to do that given the challenge to the business disparagement claim. We would want to know.
So you're saying that that these defendants are these are the defendants that he made statements to disparage your client.
So we've been informed by one of our customers that Mr. Antonelli made comments about Biot's products, and the products at issue are made by TaylorMade, and we believe that TaylorMade has been working with Mr. Antonelli to essentially undercut Biot to sell his nutraceutical products to customers in lieu of Biot's products. So we want communications between TaylorMade and DNA Health, Mr. Antonelli, about nutraceutical products, because we believe that they've been out there using using their relationship now to undercut Biot, and that factual predicate is related to the business disparagement claim based on what we've heard from customers.
This is absolute a fishing expedition, Judge. And if they have it,
I kind of agree with Mr. Bazzilli. This does seem kind of like a fishing expedition that you're asking for all communications when you don't have any evidence that it sounds like that he spoke to these particular entities.
We do, Judge. In his declaration, he admitted that he has continued his relationship. So I guess I can explain a little bit more. So at Biot, Mr. Antonelli worked with these entities, TaylorMade, in developing nutraceuticals for Biot. When he left Biot, he has continued that relationship with TaylorMade to continue to formulate nutraceutical products that are now competing with the
Is
products.
TaylorMade TMH or TMC?
It's both. There's TaylorMade Health and TaylorMade Compounding, and then there's a spinoff, Infiniwell. And we've got evidence from Mr. Antonelli's website where he's working with these entities still. He's admitted in his declaration. It's not a fishing expedition. This is based on information from Mr. Antonelli himself.
No, I disagree. It is an absolute fishing expedition. What he says in his declaration is, I have not discussed Biot's product or pricing to DNA health accounts, let alone anyone who is a Biot doctor. I acquired assets, which including account lists and any doctor who ever purchased BPC 157 directly from TaylorMade. Many of these doctors are not restricted by Biot as to who they can purchase from per their agreement or contact with Biot. At Biot, every doctor is contractually bound to Biot as it relates to hormone pellet therapy. These contracts do not apply to supplements as I didn't understand it. I have not intentionally solicited Biot's customers or clients. This is just a rank fishing expedition because they have no evidence to support their claims. That's where their whole business defamation claim or disparagement is on information and belief. They're hoping to get evidence for a temporary injunction that they currently cannot prove. The stay is designed to make them prove it, not give them access to a full range of discovery, which is what they're asking for.
Well, we're allowed discovery under the TCPA to establish our prima facie case of business disparagement. And if you read the petition, the business disparagement claim is tied to Mr. Antonelli's comments to physicians about nutraceutical products that are manufactured by TaylorMade with Mr. Antonelli, designed to undercut Biot's nutraceutical supplements.
They have no evidence of that, not one shred, and it has to be very specified and limited discovery, or they don't get it.
How would you propose, either of you propose? I agree that some type of discovery on this would be probably permissible, but this seems too broad to me. So how would you limit it?
I mean, Your Honor, it's limited to the TaylorMade entities and specific nutraceutical products. I mean, we could put a date range on it from when he was terminated through now, but just given the subject matter, it seems
but he's not prohibited from working with these entities, correct, at this point?
We could tailor it to be regarding nutraceutical supplements and their advertising or marketing to physicians, or
that's rank. Maybe it could be. I'm sorry, Judge.
Go ahead, Mr. Bazzilli.
If they want to say documents and communications where Michael Antonelli made any statements that either that the Biot's products were overpriced and that practitioners will not receive benefits. That's what they've alleged. That's what it has to be.
I think actually what I figured out what I think we should do. All documents and communications between defendants and these entities regarding Biot, where Biot is mentioned. And then if you want to do a privilege log on that, you can, but anything where Biot is referenced in the documents or communications.
Your Honor, and it's 9:40. I don't know if we have time to get through the rest of these. Maybe one more, and I'm available the rest of the day to continue this.
How many are there?
There should be 10, I believe.
There are 10 RFPs, Your Honor.
Well, let me. And how many interrogatories?
I've got the interrogatories up. There are 5 interrogatories, but they're basically saying, give me everything. So we're going to have to argue each one of them, Judge.
What I would suggest that we do is go ahead and put you guys into a breakout room, see if you can work everything out. I think you should have a pretty good feel for how I'm approaching this. And if you need additional assistance on a particular request, I'd be glad to do that. Is it just the two of you guys on this?
That's, well, there are other defense counsel or plaintiffs counsel. I will say, Your Honor, that if we're going to move into this discovery, they've offered us discovery. One of the things we have requested is the names of these physicians that they claim that we have allegedly disparaged. I mean, we have a right to know that. And they
A is designed for discovery to help us respond to your motion. It's not designed for you as the move-in. And there's good reason we haven't provided
Mr. Mazzulli, you kind of created the situation. The only discovery that's allowed now is stuff that she's right. And as long as this motion's pending, the only discovery allowed is for her to try to defeat it. And so I don't disagree with you that you should eventually get that, but withdraw your TCPA motion and we can do full discovery. That would be my suggestion if you're really concerned about it.
Understood. One of the issues we're going to have is when to produce all of this. We're going into the holidays. I will say that they set their motion for temporary injunction after 3 or 4 months. It's no rush. We could set the motion.
When is my TCPA deadline? That's the issue.
You can have, I think, 90 to 120 days. And it can be extended by agreement.
I would suggest that the deadline be 45 days before whatever day you agree the TCPA motion is going to be heard. And so, Mr. Pizzulli, if you want to agree to extend out the TCPA motion,
sure,
if you both want to, that's fine. If not, it should be 45 days before whatever day it's set.
We'll agree to extend it out. There's no problem.
Of course, we don't want to extend it, right? We're trying to get injunctive relief. We want this.
That's a good point. That's a good point. You're right. Why don't you guys try to work out dates on that while you're in the breakout room? Is it just the two of you I sent over to the breakout room, or is there anyone else here?
It is, Your Honor, but I have another hearing that I need to go to right now.
How long is that going to take?
Maybe 30 minutes.
Judge, I'm happy to have a conference with her this afternoon. We're happy to have a Zoom conference with her this afternoon and try to work it all out if that's what you want.
Why don't we do this? You guys do a Zoom conference this afternoon. If you still need additional relief, I have availability on Monday morning if you'd like to request that.
Okay, that's fine. I'll work it out with her.
Thank you, Judge.
So Ms. Brown, if you need additional relief, you can't work it out with Ms. Brazzulli, go ahead and contact Rhonda. Rhonda, go ahead and give them some time Monday morning.
Okay, thank you, Your Honor.
All right, we don't need the breakout rooms, I guess. Okay.
Great.
Good luck, Ms. Brown, and you guys have a happy holidays, okay?
Thank you, Your Honor. You too. Ms. Brown, do you want to call me?
I will.
All right, thank you. Thank you,
Thank
Judge.
you, guys.
Bye.
Lyons v. Moy Construction.
Okay, Monster on behalf of Ms. Lyons.
Garcia for defendant Moy Construction and Agustin Miranda.
Before we get too deep into this, I may be wrong. I have a couple of hearings that got set at kind of the same time, but is this the one that arises out of the tax court case?
This hearing arises out of the fact that Mr. Miranda continues to trespass on Ms. Lyons' property. She's only lived there for 29 years. And then granted, the tax court vacated their judgment and vacated the sale to Miranda in a tax court sale.
But my question, I talked to Judge Ginsburg about this, is that I kind of feel like this should be in tax court, not here.
No, we filed this case originally because the Miranda and Moy clan decided to take over this property, and we filed as a trespass tri-title. Miss Lyons has lived on this property since
but there was okay, so
1992, Judge.
I'm not 100% clear of the history. So there was a foreclosure ordered, a tax sale ordered. Judge Ginsburg apparently vacated that order But then did Mr. Garcia, did your clients take title subject to the tax sale? Or how did they get title to this property allegedly?
So they had a sheriff's deed, Your Honor, after the sale.
After the sale,
That's Exhibit
the
A.
sale that arose out of that was, is there more than one sheriff's sale, or is there the sheriff's sale that was vacated and they accidentally did a sheriff's sale?
That's that one, Your Honor.
No,
I'm sorry?
there's only one sheriff's sale involved in this, Judge. And that sheriff's sale was completed back in 2020, I think. And that's, if the court would take judicial notice of our plaintiff's first amended original petition, trespass, try title, and request for injunctive relief, Exhibit A, Exhibit C on that document demonstrates the original sheriff's sale. Then, after numerous complaints and issues and conversations with opposing counsel, and I've never met Mr. Garcia before. I don't even know if he's entered appearance in this case other than just now. But with opposing counsel, we had numerous discussions about the fact that the sheriff's sale was illegal and the trespass try title based on the longevity of her life there. 29 years she's lived there, paid taxes there, and the sheriff's sale was illegal. The filing in the tax court was illegal, should have been vacated, period. And this is the proper place for a trespass to try title, plus all the other requests we have for relief.
Okay, but you've also said in your briefing that you think that the taxing entities are proper defendants in this case, right?
We think they're newly discovered defendants, and I'm trying to reach Ms. Pamela Lee at Linebarger to discuss whether they want to make an offer so we don't have to continue with this conversation and this litigation. I've also spoken to Mr. Ramirez. Raul Ramirez is attorney in charge of this case for the defendants, and he hasn't returned my phone calls. I've tried to reach him before I filed. I've tried to reach him after I filed, and we've served the lawsuit, the first amended petition on his office, and I've also given them notice of hearing, which I wasn't required to do, but I have. So the problem is this is a proper place for this case, and we may have to add new defendants if we can't resolve it.
I know you say it's the proper place, but I'm not the tax court. I'm not sure if you're going to be suing these taxing entities because you feel that this sale was wrongful because of an order that Judge Ginsburg's issued, then I'm not sure. That would really be Judge Ginsburg's call, not mine. I'm not the tax judge. And originally the tax case arose out of the 134th, not even my court. And so I guess my thought is that there need to be should it go back to Judge Tillery? I mean, this clearly arises out of the tax sale, right?
It doesn't anymore because there is no tax sale. All of that has been vacated. There is no sheriff's deed. There is no tax sale. It's all been vacated by Judge Ginsburg. That's exhibit.
No, I get that. I get that. Mr. Garcia, what are your thoughts?
Your Honor, my thoughts are aligned with yours. This all originated in the tax suit. That's where my client received his deed and title to the property. Now that court has vacated the deed, I believe that Mr. Ramirez and Mr. Mosser have discussed filing into that tax suit to the parties to allow them to recover their attorney's fees or their such damages as a result of that judgment that was signed prior to being voided.
And he's going to know more of the history than I would. It makes sense. I guess my thought at this point is I'm going to pass this hearing. I'm going to give you guys, Mr. Garcia, an opportunity. If you want to file a motion to transfer, it would be up to Judge Ginsburg to make the decision on whether or not it should be transferred. It really appears like it's a related case to that case. The one question I have is, does he have jurisdiction over this? I would assume he does, but if Mr. Mosser, you want to brief this and say, look, he doesn't have jurisdiction under
Good.
the enabling statute. But as my understanding of how the tax court is created is that it's a visiting judge who works on our behalf. I don't know that there's anything in the local government code that limits his authority, but there may be. I don't know, but I've never had this actually come up before. But my guess is that he's going to have the case, and we need to get this done. So if it turns out he doesn't want it, then I'm glad to hear this. But I do think it should go to Judge Ginsburg first.
I don't think he has any jurisdiction over this matter, Judge. I filed this case in 2020. It's been here for going on its second year now. It'll be its second year come January of 2022. There is no jurisdiction for him to make determination because there's no deed now out of the tax court. The sheriff's sale has been vacated, and the egregious conduct of Mr. Garcia's client, Moy Construction, went in and tore fences out, tore up the landscape, tore down fruit trees. And
Mr. Mosser, didn't he do that because they thought they had a valid deed from the sheriff's sale?
No, they never thought they had a valid deed. As soon as we even heard of this concept, and the whole lawsuit was invalid because the tax court authorized litigation against the dead guy. I don't think that's legal even in tax court cases. Now, we came and told everybody what the problem is, that she has been there for 29 years. You just can't walk in and tell somebody you're evicted after they've lived there 29 years in the state of Texas. In fact, I think there's sufficient evidence and sufficient proof sitting in the files of this court, which again, I ask you to take judicial notice of your own files, and that I believe this court can issue the deed right now. And the tax court can't issue that deed. They can't even have a hearing on the deed.
Mr. Garcia.
Your Honor, in response to the whether my client knew or did not know that he had a valid deed or not, even if there is an alleged trespass that brings plaintiffs' request for injunctive relief by plaintiffs' own pleadings and declaration in support of their pleadings for this request, they've calculated damages at $50,000. So even if there was a trespass, these are calculated damages, and it's not they're not entitled to an injunctive relief because they've calculated damages. And if there is a remedy at law for the alleged trespass, then there's no need.
I don't agree with that at all. To be honest, if I have if your client, if it's accurate what Mr. Mosser is saying, and your client doesn't have a proper deed, then and your client has been trespassing on the property, they would need to vacate it, and they would eventually need to pay damages, but they would need to vacate the property. There's extensive case law that says that real estate is unique, and I've granted countless injunctions over the years, none of which have been overturned, about vacating foreclosures or whatever. I think real estate, since it's unique, you can grant that. So I don't find that argument persuasive, but I do think this issue should be heard in the tax court. But I want to let Judge Ginsburg make that decision. So
I
guess
the jurisdiction to hear this case.
I'm sorry.
This isn't a tax sale. That's all he has jurisdiction over is tax sales brought by the.
I talked to Judge Ginsburg. That is not his opinion. So you'll need to talk to Judge Ginsburg. Maybe you're right. You can brief that, and maybe he doesn't have jurisdiction. But I want him to make that decision. I think this is clearly a case that arises out of the tax court. And if it's not a tax sale, it arises out of the 134th. I mean, either Ginsburg or Tillery should hear this. This is clearly a related case to the previous case. And so it should go back to the 134th, either Tillery or Ginsburg. If Ginsburg can't hear it, it shouldn't. But that's their call, not mine. if both sides agree they don't want to try to transfer it back there, I'm okay with hearing this, but it seems very clear to me that this is a related case. But again, it's under the local rules here in Dallas County on related cases. The first filed case, which is out of the 134th, which was heard by Judge Ginsburg as the tax court, it really seems like this should be transferred there. Now, it may turn out that Tillery and Ginsburg disagree, and if they just decline to take the case, then I'll keep it. But it does really seem like that. But I don't want this to last forever. I do want to be able to get a resolution on this. So, Mr. Garcia, when can you get a motion on file?
I can get that done next week, Your Honor.
Okay.
Judge, just two issues here. I want to make sure that we're clear. One, I've asked for injunctive relief. There is no pending tax case against my client. None, zero, nada. And I've asked for injunctive relief to keep Mr. Miranda off the property. He went trotting over there after he knew that they had vacated his deed. He didn't have any right to be on that property. I know other people who would have taken stronger actions for him appearing on their property after his conduct, telling a 73-year-old lady he was going to knock her house down. He didn't have a right to be there. We need the injunctive relief to protect her from Miranda's misconduct. And you do have the authority to issue that.
We've talked about this. I'm not sure what else to say other than I don't. If there's a ruling on the merits and I'm the right judge to hear it, the question is, am I the right judge? I think it's Judge Ginsburg. I spoke to Judge Ginsburg. He thought it was. I wanted him to hear this today, but he's not in town, and so I would reach out to Judge Ginsburg. You can keep saying that, Mr. Mosser. I understand what your argument is. I just don't think I'm the right judge under the local rules to hear this. And so if you're right about all of this, then I'm sure Judge Ginsburg will agree with you, or Judge Tillery. If they decide, hey, look, that I don't have jurisdiction, or this isn't really a related case, or there's some exception under the local rules that I'm not aware of, then I'll be glad to hear this and hear it on the merits. I just don't think I'm the right judge to hear it under the local rules. So I appreciate that. And you guys have a great day. Okay. Thank you so much.
And you didn't rule on my request that you take judicial notice of your file, Judge.
That's fine. I will.
Thank you.
Thank you, guys. Okay, our next hearing is there anyone here on White Rock Montessori versus Taylor?
Your Honor, this is Robert Reagan for White Rock Montessori School.
Yes, Your Honor, Jessica Brown Wilson for the Taylors.
Okay, let's go on the record, Tony, on DC 211472. Counsel, make your appearances.
Jessica Brown Wilson with Fisher Broyles on behalf of David and Natasha Taylor.
Robert Reagan on behalf of White Rock Montessori School and Connie Lefersky.
Let's go ahead and proceed.
Good morning, Your Honor. We have a motion to compel written discovery and a motion to deem admissions. I think this should be a pretty quick and easy issue because the discovery was served on May 18th, 2021. It was due on June 17th, and we did not receive any responses. So all of the objections have been waived, and under the Texas rules and clear Texas Supreme Court precedent, the admissions are deemed. The trial court doesn't have discretion not to deem the admissions under the circumstances. So that's our initial position, is that the responses were untimely. It was when I responded to Mr. Reagan about his request for depositions. And I said, I'm not going to put my clients up for deposition because we still haven't received your discovery when this issue came to a head. In my interaction in this case with Mr. Reagan, I've sent over 50 emails to him. He's never indicated that he had a problem receiving any of my emails or any of the emails from my assistant or my staff. And there was no bounce back. You know, the email went through, it was copied to me and it was copied to my paralegal. And so our position is, you know, the discovery was served properly on May 18th and it was due on June 17th.
Your Honor, if I may respond.
You may.
On May 18th, I was out of the city, out of the state, actually. But I had access to the email and I checked the email every day, as did my paralegal, Myra Hogue. If the court will take judicial notice of the declaration of Myra Hogue, which is Exhibit B to our motion to strike deemed admissions, and is also an exhibit to our response to the defendant's counter defendant's response to the defendant's to their motion to compel here. Ms. Hogue and I, we did not receive it. We had received every other email that we'd gotten from Ms. Wilson, except this one for some reason. And Ms. Hogue in her affidavit or her declaration stated that she reviewed her email files. I reviewed my email files, and Ms. Hogue also checked with our IT coordinator, and he said that his records show that response never hit our server. Even so, we didn't see it, and the court certainly has the authority to strike the deemed admissions if it's shown that they were not answered, or if the discovery was not answered due to a mistake or inadvertence, and it did not prejudice
I guess my question is, and how I look at these a lot, is that people, you know, things happen, people make mistakes, we get a million emails. Ms. Wilson, did you ever follow up and tell Mr. Reagan before the deadline or after the deadline, hey, look, you never answered these, and you know what's going on, and he still continued to ignore it?
So I did, like I said, I think it was, it's attached, and I know it's a lot of emails and declaration, but we had correspondence in June, June 18th, which was the day after the responses were due. Mr. Reagan emailed me asking for depositions, and that's when we had conversations June 18th, June 22nd, June 23rd, where I made him aware that we had served discovery. It hadn't been responded to. We got some responses in July and August, but for the most part, the responses were all boilerplate objections. To date, we've not received documents to a majority of the requests for production. And I don't know if you recall, Judge, I don't know if it was last week or the week before, we were before you and you ordered that this was under level 2. So, you know, we take the position that we properly served it, and it was untimely, and the objections were waived, and the admissions were deemed under the law.
Mr. Reagan, why didn't you, if she told you, hey, discovery hasn't been answered, why didn't you answer them at that point?
Your Honor, we did. We answered on June 30th, which was approximately a week after we discovered that it had not been. Did you
answer the request for admissions as well?
Yes, we did. We answered the request for admission. As far as her characterization that they were boilerplate objections, we don't believe that's correct. The only objections that might be considered that were the objections to requests for productions number 16 through 65. And at the time, we were still under level 1. Now, we're under a level 2 now. We'll answer those, but we want to have the right to object to improper requests. Some of the requests we believe were irrelevant, not calculated to lead to discuss, to admissible evidence, and some of them were invasive of work product of both the school and of their school and their attorney, myself. So as a result of that, we did, not only did we answer, Ms. Wilson and I agreed that we would serve the actual documents, even though we said that they needed to come get them, make copies of them at our office. We did send and serve the documents through the court filing system on August the 6th. It took us a little while because of the director of the school was on vacation at that time to assemble those documents. But at that time, the trial was set for May 13th, so there was no prejudice to Ms. Wilson's clients for the, because of a late response. And we made every effort as soon as we found out that, we did not receive those documents to answer the request.
All right, the court is going to grant the deemed, the court's going to strike the deemed admissions for the particular motions to compel. Or I'm going to rule that the objections were not waived. And so at this point, do you want me to go through all of them, or do you guys at this point?
I think we need to, Your Honor, because contrary to Mr. Reagan's position, basically I've gotten objections to every request I've sent. This case is about two parents whose children went to White Rock Montessori. For example, we asked for all the agreements between the parties and we haven't gotten them. So, I mean, I'm happy to go through all of them, but everything that's been requested is related to the issues in the case.
And you conferred with each other on all 65 requests?
Yes, Your Honor, we conferred in August and they stood on their position that they're...
Mr. Reagan, have you conferred on all 65 individually?
No, Your Honor. As a matter of fact, we did confer on some of the documents before August the 6th, and we told Ms. Wilson that we would comply. We still had some objections, but we actually provided 230 documents to Ms. Wilson, which included some of the ones that we would have objected to. But like I say, beyond the 15 requests, we believe we were at level 1 at that time. Now we will answer those subject to the objections that we might have to the rest of those requests.
So this is what we're going to do. I'm going to order you, Mr. Reagan, to respond to those requests, any that you think are appropriate. For the documents that you produced, did you identify which documents were like, for example, did you bait stamp all of the documents? What I require, just to make it clear, is that you have to bait stamp all the documents and show which documents are responsive to which request by Bates numbers. So let's say the agreement is Bates 1 through 12, and that's request number 1. Then you would say, please find the agreement attached, Bates number 1 through 12. So you need to do that with these documents. You can't just say, here's all the documents, figure it out. You have to show what's responsive to each request. You guys need to confer on each of the individual requests, so one after another, not just withdraw all the objections. No, I'm not going to withdraw all my objections. You have to go through each one, discuss them in detail to make sure that we don't waste court's time here. And so what I would suggest we do at this point is, Mr. Reagan, you need to, finish responding to the request, make sure that all of the documents are Bates stamps, make sure that the responses identify which Bates numbers are, and then confer on all of that. If it turns out that you still can't reach an agreement, then let's reset this hearing. But how much time would it take you? I know we're in the holidays. How much time would it take you to do the supplementation with the instruction I just gave?
Your Honor, we have the 230 documents that I referred to were bank stamped each individually. And they were also, we also sent an index. I don't know if Ms. Wilson has had the opportunity to review those or review the index, but nevertheless, we've done that. Now, as far as the rest of the requests go, if none of those documents are responsive or could be responsive to those requests, we will bait stamp the additional ones. We would like to have 30 days to do this because of the holidays.
Okay, that's not unreasonable. So go ahead, you have 30 days. Go ahead and prepare an order, Mr. Reagan, that confirms this ruling. And then at that point, after you confer, after you get all the documents, all the index, all that stuff, if it still turns out and you've conferred on every single one of these individually, you still need court assistance, then let's do a rifle approach, not a shotgun approach. And I will say, Ms. Wilson, I've been in this situation many times. If you come back and you say, Judge, I want to go through all 65 of these because I think it's going to take you a long time. And it turns out he has responded and you are just trying to be unreasonable. It's, and I'm not saying you are, I don't know that, but it does sound a little like that. Just beware that doesn't go well. So try to identify.
Well, and Your Honor, if you'd like to go through some of them in our brief, we went through very specific ones that have very specific deficiencies. I'm happy to do that now.
No, I'd rather you do what I just said. Okay.
Your Honor, if I can be clear, the deemed admissions are withdrawn and
Or struck.
Or
struck.
I'm sorry.
The deemed admissions are struck.
They're struck, and the objections at this point are overruled, subject to further order of the court.
No, the objections still stand at this point. I'm going to rule that they were not untimely, and so I'm going to find there's good cause, and you have an opportunity. You don't get new objections, but the objections you've made are not struck.
Okay, and with respect to the additional 16 through 65 requests, we still, to the extent that any of those call for are objectionable, we can still assert those objections if Ms. Wilson and I can't agree.
What was your objection at the time? Just that there was too many?
That's correct.
Okay.
I would request, Your Honor, that they don't get to add additional objections at this point because we've been trying to get these documents since May.
Well, Judge, I think that was the whole point of your ruling, is that we're going to confer on all of the documents and decide which ones, or either come to an agreement on certain documents or stand on our objections to some of them. And I might also point out that Ms. Wilson has been served with requests for production and other documents which are not a subject of this hearing today, but it may be at some point that she hasn't correctly answered and has objected to. So, the shoe fits both sides in this case.
I get it. You just need to get this done. So, Mr. Reagan, go ahead and get me an order on this, and let's make sure that you guys spent your time to get all of this stuff worked out. Just 1 second. Okay. Anything else, guys?
Your Honor,
Judge,
sorry.
I just want to be sure you want this order to recite that there was a hearing on this date and you made the ruling on this
Right.
date.
Okay. At the beginning, it should say on December 17, 2021. I want you to share it with Ms. Wilson, talk to her about the form of the proposed order, and we'll go from there. Anything else, guys?
I just wanted to clarify, Judge, I thought you said that there would be no additional objections added. So we're conferring based on the current status. Is that correct? what they served.
No
and-
objection. So for the, I guess the first 15 where you made substantive objections, there's no additional objections there. For the 16 through 65, since we changed the discovery level, I'm going to allow you to do additional objections on those, but not on the first 15 where you made up. I don't want you to come back and say there's additional objections here. But you can do additional ones on the ones that were originally, there were too many objections or too many requests, and now there isn't. So he's going to be allowed to do additional objections at that point.
Okay, thank you, Your Honor. That's all I have. Oh, one other thing, just to be clear, did the court take judicial notice of the Ms. Hoag's declaration, just so it's clear in the record?
Yes.
Thank you.
Anything else, guys?
That's all.
All right. Good luck, guys. Let's get this worked out.
Thank you.
We'll try.
You guys are here on the Jackson case. I don't think that's set until 10:30. Is everyone here, or are we still waiting on some folks?
Judge, I think my attorney hasn't come on yet.
Okay. All righty. We'll wait until he gets here. It's not, we'll come back at 10:30.